Um, Jason Murakami is my name. I am a partner in the firm Bello Murakami Grant. I'm an adjunct professor at law at the university. I practice in the combined areas of um, uh, crime, domestic violence, and family law, parenting, and property. So, criminal procedure in Queensland can be broken down into 9 stages. Those stages are consistent for both defendants and complainants. And today I'm going to primarily deal with indictable offences, which are the more serious offences. The first stage is the investigation stage, stage number 1. Now, at the investigation stage, this is the stage where the police delegate and send out scenes of crimes officers. This is the place where police take witness statements. This is the stage where police consider search warrants, and this is the stage where police consider Celebrite downloads of mobile phones and laptops and the like. And it's also the stage, and more importantly, that involves ROI, which is record of interview. The single most important accoutrement in the weaponry of regulators is the record of interview. And it's this investigation stage where the record of interview is utilised by regulators. Now, we could spend a whole hour going through the whys and wherefores and benefits and the negatives of records of interviews, but for the purposes of today, the record of interview is a process that regulators utilise where they seek for a person to agree to answer questions in relation to their investigation. Suffice to say, it's at this stage here that every private citizen should request legal advice at the point of being asked to enter in a record of interview, and indeed advice can be given. Generally, not always, but generally, it is not in anyone's interest to participate in the record of interview at first instance, and I'll explain why in due course. The second stage of the criminal procedure in Queensland is the charging process. Now, as a result of the inquiries that the regulators have made in the investigation process, they will determine themselves that they're ready to charge a person. And that can be done by attending upon the person without notice. That can be done attending upon the person with notice and advising their lawyers, or it can be done in circumstances where there's an urgent search warrant that's issued and they're deciding at that point anyway they're going to execute or charge someone for particular offences. Usually the ordinary course is the police finalise the investigation stage and then they request that the defendant move to a police station, a watch house, where they request a record of interview, and depending on the outcome of the record of interview or the request for the record of interview, they decide to charge a person. Once a person is charged, the issue of bail crystallises. So the third stage criminal procedure is the first mention. And at the first mention, which is in Queensland, is in the magistrate's court jurisdiction. Now, a person can be granted bail by police, can be granted bail by the watch house, or if the police decide to oppose bail, the person can be held in a watch house, and then under the Justice Act, they're required to be made available as soon as practically as possible to appear in the magistrate's court to answer the charge as issued by the police. And it's at this stage 3 stage where you have bail issues. And what I mean by bail issues, if the police are opposing bail, the defendant instructing his lawyers will make a bail application. Certain instances, certain charges such as murder, there's no right or the bail application in the magistrate's court. The individual will need to file a bail application in the Supreme Court. The fourth stage is the committal mention stage. The committal mention stage is simply a mention, and between the first mention to the committal mention, there is a process in Queensland known as case conferencing. Case conferencing is a species which developed following the Moynihan revisions in 2012, and is a process where a lawyer is acting on behalf of an individual, liaise, correspond, and negotiate with the police or the prosecution authority in relation to the advancement of the matter. For what it's worth, I look at the case conferencing process is really much of a waste of time and resources of the government, because ultimately I take this view: how can a defence lawyer negotiate anything for an individual if they haven't been provided the full brief of evidence so they know the case against their client? But be that as it may, it is a process called case conferencing. And then what happens if at case conferencing it's decided that the defence want a police brief of evidence? It's moves to a committal mention, as I said before, and this is just not one mention. Committal mentions can be numerous. In a perfect world, you would hope to think that after case conferencing, that's between stage 3, or after stage 3, that and it's determined that the defence wants the brief, you would think that there'd be one committal mention. Well, that is not the case, and certainly since the Moynihan amendments in 2012, committal mentions can be numerous, and we've got matters, Miles is involved in that right now, but there's been something like 8 committal mentions, and we're moving into nearly close to 2 years because the prosecution is saying they're relying upon DNA evidence, and as a result, there's been 6, 7, 8 committal mentions waiting on the complete brief of evidence. But once the brief of evidence has been provided to the defence will then review that brief of evidence. They will take instructions from their client, and they will make a determination as to how the matter is now going to proceed. Now, it could well be that defence lawyers advise the matter should proceed by way of an administrative committal hearing, which is the 5th stage, or alternatively, a committal hearing with cross-examination. And this is an extremely important part of the criminal process and very much affects defendants and complainants alike, because prior with stages 1, 2, 3, and 4, really the defendants or the complainants have not had much involvement. But if it is the case that the matter proceeds to a committal hearing with cross-examination, that means that the cross-examination of the Crown witnesses will take place. And that certainly affects complainants. If back here in stage 1 they provided a statement, and that statement has been included as part of the brief of evidence, that brief of evidence, and there's been an application or a prosecution for those witnesses to be available for cross-examination, the complainant will, at the committal hearing, will be cross-examined in relation to the contents of their statement. Of course, there are opportunities as well for the defence and the prosecution not to proceed to a committal hearing with cross-examination and proceed by way of an administrative committal hearing, but that's few and far between, certainly for my office, but it does happen on a regular basis in the magistrates' courts throughout Queensland. Now, if the important thing about committal hearings as well, it's always interesting. In this day and age, people ask what are the benefits of committal hearings. Look, there is 2 cases, Morris versus the Queen, 1993, and Barton versus the Queen, 1980, which give a précis of the benefits and the role of committal hearings in the criminal justice system in Queensland. And indeed, my office often provides copies, both Morris and also Barton, to defendants and complainants alike, so they can understand what is the basis of committal hearings at stage 5. If pursuant to law, the magistrate decides to commit the defendant after a committal hearing, the matter moves into stage 6. If stage 6 is the presentation of the indictment, and let me explain what that is. That's a fancy name for a charge. An indictment is a document containing a charge in a superior court, and so from stages 1 all through to 5, that's in the lower court, the magistrate's court. But if a person is committed to stand trial on an indictable offence, there is the end of the magistrate's court's involvement, and then stage 6 and onwards now involves the superior court. So an indictment is then presented in the superior court, and essentially that is the court. The prosecution appears and says, we present this indictment to the court, the indictment's accepted, and that means that that matter now has moved from the magistrate's court to the superior court. Now, the next stage, after the indictment's presented, is potentially stage 7, and it's pre-trial hearings. Pre-trial hearings happen in Queensland prior to the trial. In Victoria, New South Wales, predominantly pre-trial hearings occur at the start of a trial, which I don't think is the best course. I think Queensland has the best system of having pre-trials long before a trial proceeds. But a pre-trial hearing is essentially a hearing where court will hear arguments by the defence as to the relevance, admissibility and reception of evidence. The important thing, particularly for practitioners to understand, at the pre-trial stage, RAD. RAD stands for relevance, admissibility and discretion. And pre-trials predominantly are made up of those 3 issues: relevance, admissibility and discretion. And so the matter will proceed to a pre-trial. And giving an example, there may well have been, back at stage 1, a record of interview taken by a police officer and a defendant. The defence have always maintained that it was unfair, or it was not pursuant to law, that the record of interview was taken from the defendant. Well, that issue is dealt with at the pre-trial hearing at stage 7, and the defence lawyers would run an application before a superior court arguing that the record of interview should not be allowed to be relied upon by the prosecution, placed before the jury. That's just an example of a pre-trial. After pre-trials, you move to stage 8, which is trial. For complainants and defendants, this is particularly the most serious stage for them, because that is where likely the statements that they provided, the evidence that they gave committal at stage 5, is now they're going to give evidence at trial before a jury, sworn evidence under oath, and to be cross-examined. And so as a result of that, a complainant will give their evidence at trial, and then they'll be cross-examined. If the defendant so decides, after being advised by their defence lawyers, to give evidence at trial, which is it's completely at the discretion of the defendant will also give evidence to be cross-examined at trial. But ultimately, trial in itself is a whole process as to the steps and the stages of trial, but for the purposes of today, it's stage 8 in the criminal procedure process in Queensland. And after trial, there's a result. And the results can be a person is acquitted, a person is found guilty, there is a hung jury, a nolle prosequi is entered. There is a number of outcomes during at the end of trial. But once the trial is over, stage 9 is potentially appeals. And appeals arise out of what occurred at the trial, particularly in relation to the evidence, in relation to the law and the decisions made by the trial judge. And those issues then could potentially be the subject of an appeal at stage 9. So there is the criminal procedure in Queensland, certainly not exhaustive, but to at least understand, for a defendant to understand where they are in the criminal procedure, or even a complaint to understand where they are, it's important to acknowledge and understand and know of the 9 stages. And if you know where you are in the 9 stages, this takes the anxiety out in relation to the very daunting criminal procedure process as we know it. Over the years, particularly since in 2001, I created with the University Innocence Project. I went to New York and spent some time at the Cardozo Law School and brought back the idea of the project. And we established the Innocence Project about, best of my recollection, it's about August, September 2021. And after 20 years of pro bono work, speaking to my colleagues at the Queensland Law Society, they thought it'd be a good idea for me to show the presentation that I used to provide to the students in relation to the criminal procedure in Queensland. And the reason why, before they started any work on cases, I presented this presentation is because I was a firm believer and still maintain it now that as law students and as young jurists, if they understood the process, then when they were doing the work, they better understood the roles that they were taking on and the work that they were doing. And so this is essentially an executive summary of the presentation that I've provided the Innocence Project for over 20 years. And I hope you get something out of it, and by all means, you might wish to adopt when you're dealing with your clients who are been unfortunately touched with the criminal justice system. One of the things I find more and more these days, because of the ever-emerging areas of practice between crime, domestic violence, and family law, this is an extremely important part of communicating to clients where they sit in relation to actual potential criminal allegations. What I usually do if I've got a client that has a breach of domestic criminal offence, which is a breach of domestic violence matter, and they also have a domestic violence matter, and they also have property parenting, I will do the criminal procedure process. I will do the domestic violence procedure process, and then I will also do the property and parenting process so that clients can completely understand the interplay between 3 areas, and also where points along that process can have effect on the individual matters. I hope this is of assistance to you. Thank you.